Hello and welcome to International Criminal Justice. My name is Rashmi Raman, and over the next 36 modules we will study the history and development of concepts in international criminal justice, which together make up the oeuvre of international criminal law. To understand the history and developments in international criminal justice, to learn the concepts of transitional justice in the context of international criminal law. In the beginning, the most important thing to understand about international criminal law is how it's different from individual law, from responsibility under municipal law. And to understand this, one must position international criminal law in the context of its history and development. International criminal law began with the idea of the end of impunity for the most egregious crimes in the history of mankind. These crimes are genocide, war crimes, crimes against humanity, terrorism and aggression. These crimes have now been codified under the Rome Statute of the International Criminal Court and are punishable with consequences determined by the international community. However, this was not always the case. Towards the end of the last century, the beginning of the Second World War brought into play a series of factors which concatenated in the creation of a collective consciousness among nation states. This collective consciousness resulted in a movement to bring an end to impunity. The interesting thing about international criminal justice is that it isn't oriented towards states. It is an individual oriented form of justice. We will see in the course of this paper how these individual discrete concepts developed and became the discipline that we now call international criminal justice. The learning outcomes of this paper are to learn about the concepts of transitional justice in the context of international criminal law. We will also study the historical development of international criminal justice in the 19th century and developments in the 20th century. Further, the concepts will propel us towards the aftermath of the First World War. Finally, we will study the creation of the United Nations and the ad hoc criminal tribunals that were established to prosecute those most responsible for international crimes. Sixthly, we will study the development of the International Criminal Court. International criminal law was developed to punish crimes under international law by international courts. The establishment of individual criminal responsibility under criminal law faced two main obstacles. Firstly, the recognition of the individual as a subject of international law, and secondly, overcoming the bias that the states had towards outside interference in their domestic matters. International tribunals mostly focus on war crimes and crimes committed in times of conflict. They exercise jurisdiction over crimes against humanity and genocide. They also prosecute war crimes, crimes of aggression and terrorism. Historically, medieval Europe developed the rules of chivalry, and the Dutch legal scholar Hugo Grotius published the first important codification of the customs of war. In his book, Grotius discusses the international conferences in Geneva and The Hague in the post-1850s up until the early 1900s, which have helped to extend recognition to internationally agreed upon conduct for armed conflict and hostilities. The horrors of World War II signaled a need for a criminal prosecution mechanism for those flouting proper codes of conduct. These included war crimes, crimes against humanity, and genocide. International criminal tribunals were established in Nuremberg and Tokyo after the Cold War ended. Conflicts in Yugoslavia spurred the creation of the International Criminal Tribunal for the former Yugoslavia, and also conflicts in Rwanda spurred the creation of the International Criminal Tribunal for Rwanda. These were created by a unanimous Security Council vote between 1993 and 1995. The ICTY, which is the International Criminal Tribunal for Yugoslavia, has successfully prosecuted 161 defendants from all parties to the conflict. These trials inspired national prosecution for war crimes as well. In 1995, at the end of the conference in Rome, the International Criminal Court was established. In July 1998, ratification started. By October 2011, 119 countries ratified the International Criminal Court. Today, more than 119 states are parties to the court. The International Criminal Court has jurisdiction over cases referred by the United Nations Security Council. The International Criminal Court deals with cases in which national governments fail to prosecute those most responsible for egregious violations of human rights in municipal jurisdictions. The core purpose of international criminal justice is to respect the rule of law in societies that have been devastated by great crimes, to provide justice for victims and punish those who deserve punishment. Transitional justice is defined as the concept of justice associated with periods of political change. This means that these are periods characterized by legal responses to confront the wrongdoings of repressive predecessor regimes. It is characterized by changes made in post-conflict situations where states, as they transition from war into peace, undergo several important changes. These changes are legal as well as socio-political. Due to political change and legal responses to tyranny or conflict, transitional justice affects both law and policy. The term international criminal justice is therefore inclusive of these socio-political mechanisms by making international criminal law as part of the legal transition from war to peace. The Latin term for this transition is jus post bellum. A new type of transitional justice has emerged: national ad hoc tribunals working with international assistance and partly applying international criminal law in national prosecutions. For example, in East Timor in 2002, Sierra Leone in 2002, and Cambodia as part of the Khmer Rouge conflict since 2003. Treaty relations negotiating the end of war and creating the first period of relative stability and peaceful relations between European states started with the creation of the Peace of Westphalia, which ended 18 years of war. Now, the Peace of Westphalia is commonly referred to as the starting point for the study of public international law. The works after that conflict, written by Hugo Grotius and Emmerich Vattel, show that there is a clear shift in the thinking about war and waging hostilities and the cause that it is based upon. Any unreasonable war was understood as an act of injustice against the enemy state or civilian. Jeremy Bentham and James Mill worked on essays separately advocating the application of a universal international code. The Lieber Code was adopted in 1863. This code was released after the American Civil War, and it was named as Instructions for the Government of Armies of the United States in the Field. The code was formed to set out some guidelines of military conduct by US armed forces. The Lieber Code serves as a blueprint for the Geneva Conventions on the Laws of War. These Geneva Conventions together make up the realm of international law known as international humanitarian law. After the Lieber Code, the Brussels Conference of 1847 was the next milestone. This conference was organized by Tsar Alexander II of Russia. The Brussels Conference and the Oxford Manual helped the formation of the Hague Convention of 1949. Jean-Henri Dunant, who co-founded an organization called Committee of Five, was instrumental in the creation of international humanitarian law. This name was later changed to International Committee for Relief to the Wounded, which was also called the International Commission of the Red Cross. Efforts by Jean-Henri Dunant led to the formation of the Geneva Convention of 1846. This became the bedrock for future Geneva Conventions dealing with hostilities in warfare. As a consequence of World War I, powerful states mobilized their forces in search for strengthened laws that would ensure long-lasting peace. Some lines from the 14-point speech by the then President of the United States of America, Woodrow Wilson, led to states forming the Treaty of Versailles, which then formed the League of Nations. The Treaty of Versailles also provided for a separate article on the formation of a special international court to try the defeated German Kaiser. The Versailles Peace Treaty of 28 June 1919 made the first recorded attempts to establish individual criminal responsibility under international law and to set up an international criminal court under Articles 227 to 230. The United States entered into a treaty with other powers that denunciated war as an instrument of national policy. This treaty is commonly known as the Kellogg-Briand Pact. However, it does not include the possibility of penalizing the individual for crimes committed. The Permanent Court of International Justice was the chief judicial organ of the League of Nations. It was formed to resolve disputes among states. However, like the present International Court of Justice, it does not have the jurisdiction to try individuals. After the dissolution of the League of Nations, the United Nations was formed at the end of World War II. The USA and UK signed the Atlantic Charter, which recognized that all nations must come together against the use of force. In 1945, on the basis of the London Agreement, the International Military Tribunal was founded, which was set up to try Nazis for the crimes committed in World War II. The International Court of Justice replaced the Permanent Court of International Justice and became the chief judicial organ of the United Nations. The ICJ's work was and remains to resolve disputes between states and to give advisory opinions on matters of law. In 1947, the International Military Tribunal was founded. Once again, it was formed on the basis of the London Agreement. The IMT had two chapters, one in Tokyo and one in Germany. After World War II, IMT trials were held at Nuremberg, and these were therefore known as the Nuremberg trials. The charter of the IMT, set up for the trial of war criminals whose offences have no particular geographical location, became instrumental in the birth of the International Military Tribunal. The IMT Charter is considered to be the birth certificate of international criminal law. The Charter's main statement was that crimes against peace, war crimes, and crimes against humanity entail individual responsibility under international law. The United Nations declared genocide a crime through a General Assembly resolution. Some important activities under this resolution include the codification of international criminal law in treaties. Of particular importance are the Genocide Convention of 9th December 1948 and the Geneva Conventions of 12th August 1949, additional protocols to the Geneva Conventions of 8th June 1977. Further, activities in the framework of the United Nations include confirmation of the Nuremberg Principle by the General Assembly of the United Nations on 11th December 1946, the creation by the International Law Commission on drafts for an International Criminal Code and a statute for a permanent International Criminal Court, in particular the ILC Draft Code of Crimes against the Peace and Security of Mankind, versions 1954, 1991 and 1996. Some important trials before national courts include the trial of Eichmann by the District Court of Justice. A very serious political crisis closely connected to the dissolution of the former Yugoslavia in the early 90s gave rise to crimes of great atrocity and magnitude. The Yugoslavia Tribunal, also known as the ICTY, was established by the United Nations Security Council under Chapter 7 of the Charter of the United Nations on 25th May 1993. The ICTY is an ad hoc tribunal and has jurisdiction over crimes committed in the territory of former Yugoslavia since the 1st of January 1991. It has jurisdiction only over those crimes that are beyond doubt customary international law, such as war crimes, genocide, and crimes against humanity. These are codified in the statute of the ICTY. The tribunal is located in The Hague in the Netherlands. The ICTY has tried criminals irrespective of their official status. This has been a substantial step forward in ending impunity. The ICTY has also strengthened victim participation. Victims are now given an opportunity to be heard in court. In 1994, the International Criminal Tribunal for Rwanda was born. It was based on a General Assembly resolution and was created for prosecuting those most responsible for genocide and other serious violations of international humanitarian law in the territory of Rwanda after the assassination of Rwandan President Juvenal Habyarimana in April 1995. The jurisdiction of the International Criminal Tribunal for Rwanda largely covers genocide, crimes against humanity, and serious violations of Article 3 common to the Geneva Conventions of 12th August 1949 for the protection of war victims and of Additional Protocol 2 thereto of 8th June 1977. The tribunal has jurisdiction over genocide, crimes against humanity, and war crimes that have been committed on the territory of Rwanda or by Rwandan citizens since the 7th of April 1995 after the assassination of Juvenal Habyarimana. The court has its seat in Arusha, Tanzania, and its appeal chamber in The Hague. In 1998, the Statute of the International Criminal Court was adopted by 120 states in Rome. This statute establishes the International Criminal Court, which has its seat in The Hague in the Netherlands. The ICC is a permanent court. Its jurisdiction is not limited to certain conflicts or time periods. However, it can only act if states are unwilling or unable to carry out criminal proceedings against the individual. For the first time, general principles of international criminal law were codified and resulted in the creation of the ICC. In 1994, the International Law Commission came up with a draft statute for the ICC. The Rome Conference was held for 5 weeks, and this marked the adoption of the Rome Statute. One of the salient features of the Rome Statute, and the one that is required for the effective functioning of international criminal law, is that the subject of the Rome Statute is the individual who commits the crime. The ICC has its own judicial and criminal branches, but lacks enforcement mechanisms. The ICC is completely different from the United Nations, but there is a relationship between the two. The Rome Statute has clearly laid down the principle of complementarity in its statute, which means that only if a state is willing or able to prosecute the perpetrators of the crime, shall the court ignore the state. In all other circumstances, the court will step in. Therefore, this duality of being unable or unwilling forms the basis of the principle of complementarity. In conclusion, in this first module, the Fundamentals of International Criminal Justice 1, you have seen how the individual is the center of the international criminal justice system. Now, this is a marked difference from the situation before World War II, where state responsibility and not individual responsibility was the bedrock of international criminal law. This nexus with the individual at its center marks an important coming of age for the discipline of international criminal justice, because bypassing politics of states, individuals can now be held accountable for the most egregious violations of crimes that the entire international community agrees are disruptive to their fabric and hurt their collective consciousness. In conclusion, in this module, you have studied the history and development of this collective consciousness through the first two world wars, culminating in the Nuremberg trials, the formation of ad hoc tribunals such as the Tribunal for Yugoslavia and the Tribunal for Rwanda, and followed by the establishment of a permanent court for international criminal law at The Hague, known as the International Criminal Court. In further modules, you will see how exactly the International Criminal Court functions and how its jurisdiction and jurisprudence differ from that of the ad hoc tribunals. Thank you.